As promised, today I'm going to talk a little bit about the Carter Page business and this whole idea of the FISA warrant, the FISA information, how it links to the Trump campaign, and why it is such a bane upon our existence. So the Fourth Amendment to the Constitution states, and I think it's important to get that right up front, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things being seized. All right, so the elements of this are, let's go back first of all to why it's there. The Fourth Amendment to the Constitution was deemed necessary because under the pre-constitutional colonial period, the king basically had the right to search, investigate, and seize whatever he deemed necessary. And the citizens of the United States, when they first formulated our Constitution and insisted upon the Bill of Rights, the 10 Amendments, the original 10 Amendments, did not want to have any occasion come up in which their rights were being infringed upon by the United States government. It is protecting them from the government. It is keeping the government at bay and forcing the government to meet minimum requirements. And the requirements are that there must be probable cause, number one, and that there has to be some proof of probable cause with an oath or affirmation, and that the search is not just, well, Joe did something in the last 10 years and we want to go investigate him for anything he may have done, so we can do anything we want to at his business, at his home, in his car. We can look at his papers, we can talk to his accountants. No, that isn't the way it works. The way it works is that they're supposed to say there is a crime that has been committed or is being committed or is about to be committed, and these are the things that we're looking for, which will prove that the probable cause upon which we have identified these acts will go to demonstrate that that's what's happened. So it allows for the seizure of those goods. Now, it also allows, if the probable cause is maintained, if you find something else in the search, then of course you can also hold it. But the search has to be legitimate to start with. And if it is not legitimate in a criminal sense, then a person can move to exclude those items, even the items of more serious nature than for which the probable cause was originally obtained, as part of the fruit of a poisonous tree. So not only does this require that these things be narrowly constrained and properly formulated, but if the state or the federal government or any municipality, any subsection of it, violates that, those things which violate it can be excluded as fruit of the poisonous tree. So along comes a little shrubby George W. Bush, and this is endemic of both of the parties. It is not peculiar to one. And on the heels of 9/11, not only goes after Afghanistan and Iraq for no reason related to it, and Afghanistan for no reason related to 9/11, and then the Patriot Act, which we have to have, right? We have to have that to protect ourselves from terrorists, which is not defined, from foreign nations, which is not properly defined. And so we passed this, and I think the only senator that opposed it is Feynman, and so there was one senator that opposed it, and a couple handfuls of House people that opposed it, even though most of them had not read it, did not know what it was about. They had to hurry up and get on the bandwagon. So along comes Carter Page. And Carter Page, I find this fascinating, that the whole FISA search stuff, which has ensnared the Trump campaign, the Trump election, pre-election, pre-inauguration election, and his early presidency. The FISA warrant originates from Carter Page. Well, Carter Page was a fellow who, at graduation, while he was a naval ROTC guy and finishing up as part of his 5-year commitment, I understand, from the Navy, was a research fellow at the House Armed Services Committee, and worked with Les Aspin as the Defense Department during the early part of the Clinton presidency. So then he was, after he graduated from the Naval Academy, he worked for Aspin, and then he worked for Merrill Lynch. After leaving Merrill Lynch, he set up his own company and associated both an American and a Russian, and they were attempting to do oil and gas trade from somewhere around 2008 to 2017. And so the idea of this is that Page then is coming and going from Russia and lived in Russia for several years, and when he volunteered to be part of the Trump campaign advisory, they had one meeting, and he wasn't even physically present for the meeting. And then he went to Russia and mentioned in passing to someone that he was going to Russia, and he was theoretically some kind of consultant for Trump, even though he never met Trump and had barely anything to do with anybody on the committee. So the association with him and Russia and with Russian officials is tenuous at best and non-existent for most parts entirely. And I will explain that that is also true for some other people that were being focused upon around the fringes of the Trump campaign in order to gain access to it. So the FISA application for the search warrant for the surveillance says something to the effect that the Rosneft president was so keen to lift personal and corporate Western sanctions imposed on the company that he afforded Page, Trump's associate, the brokerage of up to 19% privatized stake in Rosneft, an oil company, in return. Page had expressed interest and confirmed that were Trump elected, then the sanctions on Russia would be lifted. Well, Page has categorically denied that, and has also pointed out that that 19% of Rosneft would have been billions of dollars. So it would be a nice little trade-off for him, and he totally denied that that was the case. But that's in the FISA application, and it is a bald-faced lie. Now let's go on to more than that. So here's Page from 2013 on. They had a FISA warrant out on him once before, and he ended up serving as a witness against 3 Russians, 2 of which are immune from prosecution because they have diplomatic immunity, and the third one they eventually prosecuted and convicted in 2016. This is all part of an FBI sting of Russians, and Page is the witness for FBI. And then they go to the FISA folks and say that Page is a problem and that he may be a foreign agent. So here's the deal. The FISA court and the FISA system were set up to skirt around the Fourth Amendment. And everybody in Congress agreed to it, or virtually everybody, provided that it was narrowly constrained to just certain kinds of things. So the first is that there is probable cause that either a foreign power or an agent of a foreign power is the subject. So in order to claim this in the FISA warrant against Page, they have to claim that he is a foreign agent, and that the places in which surveillance is requested or will be used by that foreign agent are the places of focus. And number 3, that it must meet the minimum requirements for issuing a warrant as it relates to United States citizens. And it is designed in light and purpose, according to the AG rules, to minimize acquisition, retention, and prohibit retention of things that are found out about Americans that do not pertain to the FISA warrant. So it is reasonably designed in light of the purpose and technique to minimize the acquisition and retention and prohibit the dissemination of non-publicly available information concerning unconsenting United States persons, which is exactly the opposite of what they did. Not only that, but the warrant has to meet probable cause standards, and it has to provide a basis for that probable cause. Well, what they fudged about the FISA was they allowed the probable cause to be established by the 3-letter agency, the FBI or whatever, to say, well, we know that this is the case. And the probable cause then is narrowly scrutinized because it doesn't come from a source, a real person. So when the FBI guy comes in and says, well, I have probable cause and here's my basis for it, they used both Carter Page, and then they said, and we have corroborating information about Carter Page, which is the Yahoo News folks and the Mother Jones folks that are also saying it as it relates to the dossier, recognizing that their source, Steele, through the dossier, through Fusion GPS, was feeding the dossier and feeding the sources to multiply the corroboration, which is all really one source. So they've played with Carter Page, they played with the dossier, they played with the sources, they played with the FISA court, they signed off on it, including Comey and 5 or 6 others, numerous times to extend it, not only to gain the FISA warrant, but to extend it. Now let me ask you, if Carter Page was the source that was being considered as a foreign agent, would they, and he was already an asset of the FBI, would they have not been able to figure that out in 90 days? I would think so. So that is at the basis of it. So Page is an asset used as the front door of the Title I FISA warrant access. Not only that, but these same FBI guys are using Papadopoulos, who, like Page, hardly had any connection to the campaign, Manafort, who had connection for a brief period of time during the time of the convention, and the subject matter about Manafort had to do with what he did with Ukraine, with the Orange Revolution and the rest of the stuff that went on, 8 or 10 years ago, and with his tax avoidance regarding offshore money, holding money offshore as a result of that, and failing to announce himself as a foreign agent. Then you've got the Russian attorney that the FBI and the rest of these guys encouraged to come here, Natalia Veselnitskaya, and she had a 20-minute meeting in which she was attempting to reverse the Magnitsky Act, which kept certain people from trading with the United States, and they claimed that it was to get dirt on Clinton. That was never discussed. Nothing was there about it. Trump Jr. was in the meeting for a brief period of time, and apparently Ivanka may or may not have met her in the elevator as she passed. So tell me how much of a connection that is. And then here are the lies on the FISA application. So they failed to state that Page is an asset. They failed to corroborate with any veracity the dossier. They failed to validate the salacious material. They failed to validate the substantive material in it. They failed to disclose the sources of it. They failed to disclose that it had come from an opposing campaign. They failed to declare that they had taken the dossier and the information as a handoff from the Clinton campaign. They failed to say that the FBI had paid for the dossier or for part of it, and they failed to acknowledge that Orr, a high-level employee of the FBI, that his wife is working for Fusion GPS and is a part of the whole process. So in the process of this, they have manipulated, they've taken the FISA Act, which should not circumvent the Fourth Amendment. It is narrowly constrained, supposedly, to go after just foreign operatives. They completely avoided that. They showed no linkage between Carter Page and any foreign misdeeds. I am not so sure that Carter Page wasn't an asset of the FBI from the outset, or CIA or NSA. I'm not so sure that he wasn't flipped for it through the entire process. I would love to know that he had been, whether or not he had been paid by the FBI, whether or not the FBI, the NSA, or the CIA, or anybody else had been paying him as an asset all along while he was in Russia, while he was at Merrill Lynch, or thereafter, how much he was paid to be the informant and witness against the Russian diplomats and the Russian agent. I would love to know whether or not he'd gotten any benefit from those things, or in the alternative, if the FBI, CIA, NSA had come up to him and said, you know, we have dirt on you and you flip for us, or we're going to expose the dirt. We may have something like Manafort, some offshore income that we think you violated the federal tax code. We may have salacious materials ourselves. We may have things that you did inadvertently. You may have failed to identify yourself as an agent for the Russian government or for somebody else. Any of those things for which they can charge him and flip him. So they either paid him or flipped him, or both, and he was an asset at the same time that they were using him and accusing him of being a foreign agent and going to the FISA court so they could gain access to Trump. Now, how do you like that? How do you like the mix of all that? And they attempted that same kind of thing with at least 3 other satellite people that are out around the fringes of the Trump campaign. And even then, even with Comey in the middle of it, Rosenstein in the middle of it, Mueller in the middle of it, and all the rest of these folks working in the FBI and in the DOJ, they've spent a year and tens of millions of dollars trying to find a linkage that the MSM says every day is obviously there. And so far, at least, they've got nothing. And what they have, even on Papadopoulos, Manafort, etc., is so tangential and unrelated to Trump being linked to Russia that it's crazy stuff. So it is enough to make someone furious about the entire process. So people have talked about whether or not this is treason. And certainly the pieces, the individual pieces, the false statements to the court is not by itself treason. The FISA application by itself is not treason. Using these people illegally and unlawfully is not treason. It does constitute other federal offenses, and it also puts these attorneys, all of them, at risk both for ethics violations, for recusing themselves, for having their law license revoked, all of those things. The appearance and use of a court, misuse of a court, could be 1 to 5 years. But listen, collectively, where you look at them attempting to use all of these individuals in all of these situations to bring down a lawfully elected president in the most devious and offhanded sort of ways, does come close to appearing to be sedition or treason. So I'm going to do something more on the FISA stuff and the whole Patriot Act and the Freedom Act, because I think it all links. But this is the stuff that others have talked about in pieces, certainly. Some have talked about in composite. But the relationship between our Fourth Amendment and why it protects us and why it should not be used at all, but the use of it to sneak under a federal or foreign illegal activity and then use it for against Americans, which is in fact what FISA has done throughout. I mean, 90-odd% of the arrests made as a result of FISA have nothing to do with foreign governments or foreign intervention or illegal acts having to do with foreigners. So they're playing with it at best, and they've horribly misused it here, and perhaps have used it in a traitorous way to attempt to take down a president. Thanks for your information. Hey, listen, a lot of the comments that I've gotten are incredible. I'm sorry that I haven't responded to all of them. Give me a thumbs up if you like what I'm doing. Subscribe if you think this is worthwhile, and put more comments down. I'm following on some of them. You know, it ends up being a huge day every day just following on it. But you guys have been wonderful, and I do appreciate both your involvement, your engagement, and subscribing. Thanks so much.